The matter of State versus Hernandez and Sanchez, may we please have appearances?
Harold Henderson, Assistant Attorney General on behalf of the state.
Good morning. My name is Michael Hernandez. I represent Cesar Hernandez.
Good morning. May I please call my name is Charles Alvarez, law office of Peter Willis, and I represent Mr. Jose Sanchez. Lawrence S. Musberg, to the DC on behalf of the Legal Security Association of Criminal Defense Lawyers.
Good morning, counsel. Happy New Year and welcome. Ms. Henderson, you may proceed.
Thank you, Your Honor. I'd like to reserve 2 minutes for rebuttal if necessary.
That's fine.
This case involves an unprecedented and an extraordinary discovery order in a rather ordinary drug case. The facts of this case indicate that there were 3 controlled drug buys by a cooperating witness with the state, who before each of the buys was thoroughly searched to ensure that they had no drugs on their person. The alleged purchases took place in an open area in an automobile that was under surveillance the entire time by law enforcement. After the transactions occurred, the cooperating witness was searched and then turned over the evidence. There was also tape recordings of the transactions that occurred. That's essentially the proofs of this case. Because we have a cooperating witness, like in accordance with the law, and any witness we have that has any type of outstanding charges, cooperation agreement, anything that could affect their credibility, that's clearly discoverable and is turned over to the defense. And that was done in this case. There was an extensive cooperation agreement with this witness. There were 2 agreements. One was in November of 2011, one was in January 2012. They were turned over. It essentially spells out exactly what this individual, what benefit he can expect for his cooperation, depending on what happens in different cases. He himself had been charged in another case and had pled guilty, and so this was all affecting the sentence he would receive in that case. But everything was spelled out. There are 4 investigations involved. One involves the defendants, one involved his own case, and then there were 2 other cases. So discovery was given on all the favorable cooperation as he expected to affect his sentence, anything that, whether he was paid or not paid, anything that's covered by the case law. Well, the defendants in this case wanted additional discovery. They wanted discovery of the factual information in all the other cases. The trial judge said they were entitled to it. And what the judge had ruled was that they were able to get statements that our cooperating witness made in all the other investigations, all the investigative reports in the other investigations, summaries of any of the interviews of that witness in the other investigations, any tape recordings or CDs of that witness in the other cases. And then the most extraordinary one was the judge said we would have to create a privilege log of all internal memorandum by our office that involved this individual, and they wanted us to search all our emails for any time this individual's name was mentioned and create a privilege log. With respect to the last one, the discovery rules clearly say that they're not entitled to discovery of our internal memorandums, and certainly not our emails back and forth about a case, which could be anything from what day do we want to have a meeting on this case to what's going on in the case. So we're talking about thousands of documents that, with all this discovery, the judge essentially said we had about 5 days to get together. Clearly the judge's decision was an abuse of discretion, which is the standard for this. First, because it is clearly contrary to law. All the case law cited by the state and also by defendants all involve situations where discovery is given of information that could be used to impeach the individual. Any favorable treatment, any expectations, cases involved where they were essentially an employee of the prosecutor's office because they were paid on a continuing basis, anything that could affect their credibility. The factual information that happened in these other cases, how those drug buys went down, or the other crimes occurred, what happened factually in those cases, have no relevance to this case. And even the trial judge admitted that these documents are not relevant. She repeatedly said they're not relevant and they're probably not admissible, but they're discoverable. And our feeling is that clearly relevance is the main thing for discovery. If it doesn't fall under the discovery items that we have to automatically turn over, then the defendant has to make a motion to show a need, why he needs it and why it's relevant to the case. The argument had been made that this falls under the normal discovery rule because it's a statement of a witness. And our position is that it's implicit in the discovery rule. When you're talking about discovery, you're talking about statements and all the information we have to give over that relate to these defendants, to their indictment, to their cases. It doesn't relate to anything, any of our witnesses, any other case they may involve in any time period, or even contemporaneous. What's important is what they can be impeached with. And we don't dispute if there's anything that goes to impeachment, they're entitled to it. And if defendants had come forward and said, we're looking for this particular type of thing, I think an allegation had made, or I said, well, what if he made a false accusation against someone? There's no proof he ever made a false accusation against anyone, but if you said to us, please check these files to see if there's anything where there's a false accusation. That's a limited request that could be done. Now, given the fact that all those other cases resulted in indictments, it's unlikely that there's any false implication of anybody in the case. And in terms of the type of cases, the one case itself that involved this cooperating witness had 20 co-defendants. It had hundreds of hours of tape recordings, which those cases never went to trial. They all ended up in guilty pleas. So those tapes were never transcribed. So for this discovery quest, we're going to have to go back and listen to all those tapes to find out any of the conversations, their tape conversations, of where it involves this individual or where the individual is mentioned. And then we'd have to provide it to the trial court for an in-camera review. What the purpose of this, where it has no relevance to what was said in a different drug investigation, because there's no connection to the defendants in this case, in any of the other cases. They have nothing to do with them. There's no co-conspirators. They're separate cases entirely. So we just think that the discovery order in this case was really an abuse of discretion and really contrary to law. And the problem we're having now is that we are getting Hernandez motions in many cases, not just cooperating witness cases. We're getting them in any case where we have a witness that has an outstanding charge.
Ms. Henderson, I didn't want to interrupt your
No,
opening
I'm
statement.
done.
You went through some of the items, perhaps all of the items. Can you clarify for us the scope of the order as to the 5 other cases? What are the precise items that need to be disclosed under the trial court's order?
Okay, there's 3 other cases and this current case. The first item was statement of the cooperating witness and investigative reports and the 4 matters identified by the state in which the witness provided information. So we're talking about any statement that witness gave in all the other investigations. Then we're talking about summaries of any of the detectives in any of the matters regarding interviews with a cooperating witness. So not just the statements they made, if there's any summaries that any of our investigators made of meetings they had with this witness. Tape recording and CD of the cooperating witness. So this would involve his own individual case where there were multiple defendants and their tape recordings of all conversations that took place during that conspiracy, which my understanding is it's hundreds of hours of recordings that were never transcribed. And in the other cases, I'm not aware if in the other 2 cases there were any tape recordings or not. I know in this case I believe there were. I believe he was wired up during the investigation. And then the last one is a privilege log on the internal memorandums and emails in this case and the 3 other DCJ investigations. So the discussion had been, aside from our internal memorandums, which the judge looked at and was going to decide whether or not they were privileged or not, they wanted us to do a search probably of the last 5 or 6 years of our emails of all the attorneys that had anything to do with this case and all the investigators to search for anything where his name is mentioned. And he has a fairly common name, and certainly his nickname is even more common. It's Dollar. So if we're doing a search for Dollar, I think we'll blow up with the machine trying to find that. And again, the whole point is, why is that relevant and why is that discoverable? That's our internal communications.
Well, leaving aside the privilege log for the moment, with respect to those the 3 items that you mentioned, the statements and the summaries and the tape recordings, the theory on the defense side is, how can we tell if there's a false statement unless we see the statements and then find out something more about the case? And the fact that there were indictments coming out of those investigations doesn't necessarily mean there was no false statement. How do you respond to that?
Well, it depends on what you characterize as a false statement. If the statement is that whether he falsely accused someone and knowingly did that, that's Brady. I mean, if we have information in our files that this guy is lying, one, we're not going to be using him. The cooperation agreement's going to be off. And he's not going to be a witness in a case. So, there's no question if there's any false testimony, and the whole cooperation is based upon you're going to have to give truthful testimony and information that we're going to verify. I mean, it's a cooperating witness. I mean, in this case, he was under surveillance the whole time. There was a wire on him. I mean, we're not going to take him at his word.
Just to be clear, so you're saying if the discovery request were limited to providing information concerning false statements provided by the confidential informant to law enforcement, you would make that available to the defense?
I think Brady, we would have to do it if he made any false statements in the other cases.
I'm asking, forget about Brady or anything.
Yes, we would.
You're making a representation. You will provide that to the defense attorneys.
Sure, if he made any false statements.
What about
I mean, it depends on what we're not talking about minor inconsistencies. I mean, we're talking about absolute falsehoods that go to the materiality of the case.
So that's another area your adversaries bring up, of course, that they seek this information to be able to gather inconsistent statements to use for cross. Can you respond to that?
Well, you can't cross-examine on inconsistent statements in other cases. They can't be impeached with information in other cases, with prior conduct in other matters. I mean, he can be cross-examined on any inconsistencies in this case, but we have inconsistencies in every trial. I mean, whether it's a police officer, whether it's a victim, and whether it's a defendant. People's memories fade or whatever, and they're going to be cross-examined on that. That doesn't mean it's evidence of falsehood. It's just, a way of attacking someone's memory or someone's ability to recall what happened. And that's a different issue than someone falsely implicating somebody in a crime. And clearly, as I said, if that was the request, could you search through these files to see if there was any information that he gave false material testimony or evidence or information? That would violate our cooperation agreement. And ethically, we are not going to use a witness who's lying to us. I mean, if they're lying to us, then all bets are off.
So I just want to take the word material out of it. Would you provide to the defense false information provided by the confidential informant to the prosecutor or to the appropriate law enforcement authorities? False statements, not
Well, I guess we'd have to define the false statements. It can't be minor inconsistencies.
How about known to the state to be false?
Absolutely.
Okay.
That's Brady.
Right. I mean, if we got someone giving false statements, even without asking, we're going to turn the stuff over. But assuming that they want to ask to make sure, we want to be specific to make sure we know what you guys are doing, and to check this guy, to say, we want you to check these files to see if any time he gave a false statement. And again, there may be we may quibble. Let's say if we say we'll give all the false statements, we may quibble later on in front of the judge over whether it's material or not, in terms of, if he said it was 6 o'clock at night and it's 8 o'clock at night, I mean, or whatever minor type of thing it was, but certainly any material thing. But even aside from any false statements, I don't see any problem with that. I mean, that's a specific request, and that's something that, is manageable to do if we're looking for false information.
Is it your desire to try to limit the discovery request to issues that might go to credibility that are outside the range of speculative inquiries into credibility, as opposed to your known falsehood standard, which is a more objective one that can be applied to the discovery request?
Yes, and we think that's in conformance with the law, because when you read all the cases about impeachment of witnesses, it all goes to any interest or bias or anything that could affect their credibility. Speculative things about what they may or may not find, and factual information. I mean, at one point there was some claim that they want to evaluate, how good the information was he gave in other cases. I I mean, that's for us to evaluate in terms of whether or not we're going to give him a deal or not, or how good the cooperation is. You know, it's not for a defendant to say, I don't think that information was good enough, and you shouldn't give him a deal.
One of the arguments made by the adversaries on the other side is that there is reason to worry and try to go beyond into some more speculative aspects, because the nature of this cooperating agreement is almost in the form of a bounty. The more cases that the cooperating witness brings and makes available to be pursued by the state, the greater opportunity he has to reduce his sentence. He's already gone from life to 14 years, and he has the capability of, he did have the capability of bringing it down even further. So is that a reason to range beyond clearly known falsehoods into what you call more speculative areas for impeachment in order to allow these defendants to properly present their case?
No, because he can be cross-examined on saying, isn't it an incentive for you to bring more cases in order to get a better deal? But our cooperation agreement is really based on this court's decision in Gerns, that when we make a cooperation agreement with defendants, it always comes down to, in the end, is that they think their cooperation was better than we think it was. And as this court said in Gerns, we should spell out exactly what they're looking at, what they can expect, and what they have to do to get that. And since it's all spelled out, they can cross-examine him on this. I mean, if the point is, oh, it's in his incentive to bring more cases, and how can we trust him, that's what you cross-examine him on.
It makes it more like a grant of immunity. It's a done deal, assuming you know you comply with the parameters, and there's not this ongoing expectation of making it better.
Yes, and we also had difficulties with cooperating cases where we would say the cooperation, and defendant would come back, or the cooperator would come back with a case that we make a fourth or third degree drug offense, and he's facing first and second degree charges. Well, we're not going to reduce your sentence if you're giving us low-level people that aren't equal to you. And we used to get into disputes over that, where we would essentially have hearings where we'd bring police officers in, and defendant would testify and his lawyer would testify about, you know, no one told me I had to bring that good a case, or no one told me this, and this was my expectation.
I found there something very unusual about this cooperation agreement. Perhaps you can comment on it. And it's not necessarily the focal point of the arguments here. The cooperation agreement not only required truthful information, it required a successful prosecution. Am I correct about that?
Probably, yes.
So despite however truthful the confidential informant might be, unless he actually got the defendant, he wasn't getting anything. And that would seem to create like the greatest incentive for a confidential informant to start really revving up, maybe even beyond the truth.
Well, I mean, we want a successful prosecution because they don't want us giving evidence that's not going to hold up, or
But
cases.
juries can be fickle, as you know,
Absolutely.
as any. And saying that truthful information isn't enough, you got to nail this person and make certain that this jury gets him. Struck me as something I have not, quite frankly, seen in cooperation agreements. Am I mistaken, or am I an old fogey on this?
You're mistaken, because
Okay.
they do have both, I believe, in the federal and the state level, that they do say that it has to result in a successful prosecution.
So explain to us the policy reason behind if the cooperator performs in a way, before the jury's verdict comes back and after the evidence is in, the state believes was 100% or 110% of what could have been expected. Why would the cooperator not be entitled to the benefit at sentencing if the jury verdict came out one way or the other?
He may be. I mean, the agreement puts it out. Again, I didn't write the agreement, and it's not really the focus of the appeal, but we're looking for cases that can be proved in terms of he may give us information, and we pursue the information, and it turns out not to develop into a case, and it may have nothing to do with him. I mean, not every case with a cooperator involves them doing the case themselves. They provide us information, and then we can use that information to try and develop a case. And his information may be truthful, but the case may not develop. And sometimes they give us information about
And at the time
Yeah.
you're doing a plea agreement, you know he's going to testify in a case. And when you say that truthful information isn't enough, you, Mr. Cooperating Informant, have to now persuade this jury. That seems to be a powerful incentive to people who are often very desperate to please their keepers.
Well, that part of the cooperation agreement doesn't necessarily mean that he's the one making the case or testifying. We do have cooperating witnesses who give us information that leads us to an investigation that does not involve him at all personally, that he may not be testifying in the case, that, you know, not every case with a cooperating witness involves them doing the buys themselves or being a witness in the case, that they're providing us with information that we can pursue the case. So it doesn't always mean that the incentive is that he's got to make sure he's got this conviction or he's not going to get the deal he wants. And certainly, you know, if it was a case and if something went, you know, the jury, you know, reached a verdict contrary to what we want, doesn't necessarily mean, there's always leeway in the agreements that if we think the individual did the best they could, that we're going to give them the benefit of it. But I think we're putting out there in terms of expectation, because we don't want them giving us information about drug organizations or things that have already died out, you know, giving us stale information.
Perhaps it's a matter of language, because what we hear you describing is that you're talking about successfully pursuing an investigation or bringing charges in a matter, and the way that it's the literal language here can be read otherwise. So,
I mean, that's possible, but that could be, you know, debated with, you know, that could be brought, what you just said to me could be brought out in cross-examination and say, you know, doesn't this really say you have an incentive to really embellish this case, and that, you know, you're not going to get any benefit unless my clients get convicted.
But see, this is part of the engine that's driving what they want, because the defense is saying that you've now created such extraordinary incentives for this confidential informant to lie. We want to look through these other records, and then they've come up with all this social science data that indicates that there are a high percentage of wrongful convictions based upon these so-called snitches or confidential informants.
Well, I don't think you need an expert to know that confidential witnesses and even witnesses that are testifying to get a more favorable plea agreement have to be looked at suspect. I mean, that's why we have jury charges on it. That's why they're cross-examined on it. But I don't think that the way the cooperation agreement is written is to ensure that they're going to get a conviction at all costs.
Did the trial court cite that provision of the agreement in ordering this discovery?
No, this is the first time I'm hearing it. It wasn't in any of defendants' briefs. It wasn't argued below, and it certainly wasn't a basis for the judge's decision.
Ms. Henderson, you said that the additional information is the credibility of the CW, the confidential witness, is not make or break in this case, and you cited the fact that we have tape recordings of the transaction that took place, right? Don't we have?
I don't know what's on the tape, but yes, I believe there are recordings.
And that has been provided to the defendants,
Yes.
correct? And wasn't there also a forensic analysis of the cocaine that was obtained from that transaction?
Yes.
Okay. And also, were defendants provided with they have gotten the plea agreement, the plea form, so they know that. They know he's going to testify. They know his name. They know his criminal history. And they have the cooperation agreement.
That's correct. So they have everything in this case. And in fact, the discovery request, the additional discovery request made, had nothing to do with this case, with any of the facts of this case. It had everything to do with the other cases.
Credibility, what you would call perhaps a sideshow.
To me, it was a fishing expedition. It's like, we want to look, give us all the other files, and we want to look through it to see if there's anything there we can use.
Mm-hmm.
And, you know, when the judge was even finding that the evidence wasn't relevant, I'm sorry, you know, what happened factually in the other case, whether the individual was charged with whatever he was charged with in his indictment, with racketeering or whatever, or a drug transaction, what that has to do with defendant's case is beyond me. And the same thing, if there's two other cases where he bought drugs from individuals, what that has to do with the fact that these individuals allegedly sold him drugs, I don't see how that possibly could come out at trial. in terms of the factual information. Again, if we're talking about credibility information, we don't have any problem with that. And the information about the cooperation agreement, that goes to credibility. That's clearly, grounds for cross-examination. And the same thing, if they ask specifically, is there any information that he gave false information in the other cases, clearly that goes to credibility, because, we do have, one of the, the evidence rules that says, evidence of false accusations, if done knowingly, is admissible for impeachment purposes.
Ms. Anderson, can I go back to the language in 4B for just a second?
Sure.
Resulting in the successful prosecution. Speaking for myself, I didn't view that as central to this case. My request is, can you go back and explore with your office the phraseology that's used there in light of what has been part of the back and forth with us today?
Okay, so we're not comfortable that it has to result in a successful prosecutions.
Well, a plain language reading could suggest that unless there's a conviction,
Unless there's
you
a
get no
conviction.
benefit. And you've offered a number of alternative ways to read that. I'm asking if you would represent to us that you go back and explore that language and look at it with your office.
Absolutely.
Thank you.
I'm sure some of them are watching the argument now, so I'm sure I'll hear all about it when I get back.
Can I ask you a question about this? There's an appellate division opinion that I believe is cited by you and also by the defense, and it says something along these lines, that the defense is entitled to evidence, to material that will lead to relevant evidence.
Yes, I think
Okay,
yeah.
The reason why I'm raising that is because when you look at Rule 313.3, it says you're entitled to relevant evidence and material. That doesn't say will lead or may lead to. So,
Well,
is it your opinion that that's good law? That they're entitled to information that will lead to relevant evidence?
yes, and that would be the basis for them to make an additional discovery motion that is not based, because the items in the discovery rule now are things that are clearly relevant. So they don't even have to ask for it. I mean, when you go through all the stuff, obviously it's relevant to the case, and that's kind of like a catch-all provision to say, if despite that you think there's other relevant evidence out there, that you can make the motion for it. I mean, like the example
it says information. I may not be quoting it precisely. I think the appellate division case says information that will lead to relevant evidence.
Right, I think that's to the civil discovery.
It's a ci-
rule.
we're
It's
talking
not
No,
about-
I know that that's
Yes.
the civil, but that there is a criminal case. It's cited in the briefs, and I think in yours as well.
And
Do
certainly-
you have no problem with that?
If there's a basis to believe it will lead to relevant evidence, if they can explain why it's relevant to the case. Here, none of this, we've never gotten an explanation on why this evidence, this expansive evidence, I mean, why the tape recordings of all these conversations are relevant to this case.
If I could follow up on Justice Albin's question, because obviously in civil practice, discovery is extremely broad, and a party can ask for information that is not relevant, not admissible, but is reasonably calculated to lead to the discovery of relevant evidence. And I think what Justice Albin is asking is, what is the state's position as to whether that is the rule in criminal practice, or is it a more limited scope of discovery that has the term relevant now? What is now being asked for is relevant to this case.
Yes, our position is we're not as broad as the civil discovery, and there has to be a relevance argument to say why you think evidence may be relevant and why this could lead to it.
Yeah. So the appellate division case does not use the civil language that may be reasonably calculated, because that is really the broadest form. But it says will lead to. Information that will lead to relevant evidence must be disclosed.
But you have to have a good faith basis to believe that. You
I'm not
can't-
suggesting, I'm just telling you what the appellate division opinion.
Well, it's an
That's-
appellate division opinion, I'm not sure which one it is, and if it was only used once, I don't know how widespread that is. And quite frankly, I mean, this is really an extraordinary type motion. I never know of any other case where they've gotten discovery. I know they've asked, at least in one or two cases, and you can see from our appendix, it's always been denied. So it was never found to be relevant before, and this is much more expansive than anything in those other cases that were involved. And it's just,
So is it the state's position that Rule 313.3 limits discovery in criminal matters to relevant information, as opposed to information that may lead to relevant information?
Well, I think it is limited you have to relevant information.
To this case.
And clearly the type of evidence or type of information that's given in the discovery rule, it really in most cases is sufficient in every case. I mean, it's rare that you see additional discovery requests, and recently the only one that comes to mind is the one where they wanted to inspect the victim's home. And that was one where they made a specific request, and they explained why it was necessary and what they thought it would lead to. And it was very specific. They explained the relevance, they explained the necessity, and there were limitations placed on it, and that was the ruling in the case. And it said in the future, if there is anything else that could come to that, then it's a basis for a motion. But generally in most criminal cases, you're not getting beyond what's in the normal discovery rule, and generally that's enough.
Any other questions?
Just,
Thank-
can I just ask one, to clarify, because it's been kind of all over the place. You're not suggesting that if the defendant came forward and made a showing that certain specific things he's asking for, while not relevant, will lead to relevant information. If he makes that showing, makes that argument in a motion, then he might very well, under that appellate division decision, be entitled to it, if he makes that showing.
If a defendant is able to make a specific showing that he has reason to believe that that this information will lead to relevant
Right.
evidence, and he can explain why that evidence is relevant, that very well may be done. I mean,
But you're just saying that wasn't done here.
No.
It wasn't required here, and there's been no such showing.
no.
Okay.
And there really
I thought
was
that's
no
what-
decision by the trial judge on why the discovery was ordered.
Understood.
Essentially, the trial judge just said, I rely on 2 or 3 appellate division cases that all limited to impeachment evidence. Nothing like the discovery in this case.
By the way, just to make sure, because I thought all of the cooperation agreements of this CW were provided, correct?
They were, that is correct.
So they know everything and all the terminology and all of the cooperation agreements in all the cases in which he had an agreement, correct?
That is correct.
Okay.
Because in the other cases, the other cases all were resolved,
I understand.
one way or another, but...
But they've got all of them to use for impeachment purposes.
Absolutely. And they know all about the other cases and the benefits. The agreement, as we said, does spell out a lot of specific things that, there's a lot of pages there. There's a lot of grounds to go after this individual, but, this is not a big racketeering case. This is, 3 drug buys that, that were surveillance, that were controlled buys, that, that this is not one where, they can impeach the credibility, but it's a relatively straightforward case.
Thank you, Ms. Henderson. We'll have you back for rebuttal. Mr. Korbanix.
Relatively simple, ordinary drug case. This is not. In my experience, and I'm trying the case down below, I have never seen a cooperation agreement like this. And quite frankly, had we not requested further discovery, my client would probably be here on ineffective assistance of counsel. This is far from a fishing expedition. This is a case that shows forms of gamesmanship in discovery. We didn't just ask for anything. And the timeline of this case is crucial to see why the defense is so suspect about the discovery in this case. The cooperating witness entered a cooperation agreement in October. That was the first one. He then did a 2-week investigation that directly affects this case, in which Dollar makes 3 buys of 50 grams, 50 grams, and the third one is of 60 grams. And that is important for this court to know, because that was his make it to the Rose Bowl, coach, and you get additional incentives financially. He got additional incentives time-wise, because when he gets a second-degree case, he only gets 6 months off his stip. When he gets a first-degree case, he gets 12 months. But that's according to which cooperation agreement you want to follow. Because after he does this so-called investigation, they enter another cooperation agreement. That one's dated in January of 2012. That's called, which I've never heard before, a superseding cooperation agreement. And that's the first one we got 2 weeks prior to trial, not in a normal course of discovery. 2 weeks prior to trial, we get the superseding agreement. We read it, and we say, wait a minute, superseding, that means something came first. Could we please have that cooperation agreement? Now, mind you, this is mid-January, and we're supposed to start a trial in February. And we get that first cooperation agreement. And it's different. It's different because it has different investigations. The numbers of credit change. It's got redactions. And the interesting thing about the redactions is, one thing I've learned in this business is never to assume. So if you look at the two cooperation agreements, which is redacted, talks about first-degree drug case in the original one, with, I believe, an 18-month reduction, as opposed to the superseding cooperation agreement, which names our clients, in January, names our clients that the investigation the previous month took place. I don't know what that redacted words are from the first cooperation agreement. But we're not fishing. And we're not saying there may be inconsistent statements there, because when you compare those two paragraphs, in the original agreement that we got second, whoever's in that blacked out, redacted names they were supposedly able, Dollar was supposed to be able to get weapons, because if he got weapons from them, he got another 6 months off. In the superseding agreement, there's no mention of weapons in that paragraph as to these two people. So this isn't a fishing expedition. And I actually stand here today at a little bit of a loss because of the stay in this case, because in one of the letters that's in our brief in the appendix, that originally states from the Attorney General's office to the attorney. See, that's why we ask for attorney communications. It sets out the basis for the plea and cooperation. And one of the paragraphs in the letter to Mr. Reisman, his attorney, says, contemporaneously with this cooperation and agreement, cooperating witness, will give a statement regarding all his criminal involvement and what he knows. Statement of a witness. I don't think that's a very intricate legal issue according to the court rules. When we originally asked for it at the trial court, while we were arguing this out, we were told that was put. We don't know if there's an agreement, which I hate to digress, but we stand here and talk about obligations of prosecutors to go through. This is a cooperating witness, not a confidential witness. Cooperating witness. And they're talking about going through documents. That should be done. There's obligations to do that before he hits the stand in any trial. We're talking about things we don't know.
Mr. Kerr,
What I didn't know about, I'm sorry.
Finish your statement.
I'm getting somewhere with it, is we later learn, and we don't have it, that contemporaneous statement he gave cooperating witness was 71 pages. Hasn't been turned over to us yet because there was a stay in the proceedings. So I don't know how that works in conjunction with these cooperation agreements. But clearly this is not a fishing expedition, and it's not an ordinary drug case. Because in ordinary drug cases, in my experience, when you use a cooperating witness, usually you use that to introduce law enforcement. So you don't have to put a cooperating witness on the stand. You introduce an undercover officer. Interestingly, in the timeline of this case, is there's only one tape recording, and it's not exactly legible. The other two really didn't come out with the body wire. They really didn't come out clearly and probably have no evidential value. These defendants in this case were not arrested. Were not arrested till a year later. No drugs were ever recovered from them. There's not the ordinary marked money. And interestingly enough, I think whether or not this cooperating witness was surveilled is a question, because these alleged transactions took place in a car. There was no...
Mr. Corbanix, let me interrupt you just to focus us a little bit here. We need to assess whether the scope of the discovery order that was entered in this case is appropriate.
Right.
And as we've heard, it extends beyond your clients. It requires the disclosure of tapes and detectives' reports and emails and so on as relates to other investigations having nothing to do with your clients who are awaiting trial. So you need to tell us, for example, why the tape recordings that were made in those other investigations are relevant for the discovery in this case.
Interdependence is the word I would use to say why they're relevant. Because this is not a normal cooperation agreement. Each time this cooperating witness came forward or made a statement, it was interdependent on other parts of this cooperation agreement. For example, if he lied in another investigation, or that investigation wasn't successful, that would mean it is all the more important that this prosecution be successful, because he lost the chance of that bonus in the other investigation.
You have all those cooperation agreements.
You make that on
You know all
cross.
that interdependency.
But
And you
Mazur
have
tells
all-
us,
And you have all the lies as well.
but I don't have the lies.
To the extent that there are false statements that were made in the other cases, you have or will have those if they exist.
I don't know if I don't know if I will have those.
You just had a representation from the Deputy Attorney General, Ms. Henderson, that if there are any false statements that are given by the cooperating witness in any of those other cases, they'll be provided to you.
I don't think that's enough.
So let's stick with tapes as an example. You get hours and hours of tapes in one of the other investigations. How will that lead to discoverable evidence? And or how will you use those tapes themselves in your case? How would that be permitted under the rules?
Well, under the rules, I think with the judge's discretion, we actually have the judge down below actually structured the perfect way to do that. Is these are not, under the judge's ruling below, being handed over to us to go through. She's the gatekeeper. She's going to look at those statements and look at those things and see what's relevant to be turned over. Another interesting thing about those statements is they say, we don't know. How could we not know? We're basically on the eve of trial. We were going to start this trial. Had this stay not came, how do we have a representation that they don't know what those statements are. They don't know what exists there. But all I know is I have a cooperation agreement that says that the first one is null and void. I don't know what caused it to become null and void.
So again, please, to
Yes,
the extent that you can, based on your experience, you've got your case and you've got some other drug case that doesn't involve these defendants. How does the evidence from those other cases give us an example
I'll give you an example.
of what would be relevant that would come in in cross-examination in your case, or lead to cross-examination material in your case?
I do know from the cooperation agreements that he was going after other people as leaders of narcotics. So, for example, if there's an investigation where it appears from those tapes that he is perhaps shunning the police away or investigation from that one person, and because he's shunning the investigation away, he's going to ensnare our client, that could be an example.
This sounds so speculative. I don't even know, even if you found a false statement in one of those other cases, under our rules of evidence, I don't even know how you'd get that in. It's collateral. Specific instances, I don't have the evidence rules in front of me, but specific instances of conduct that are not evidenced by a criminal conviction, generally, okay, are not permissible. We have that exception for false accusations. The things that, other than the cooperation agreements that Ms. Henderson is willing to provide, and she's also made representations of any false information that is provided, it seems to me that you're like just foraging for evidence.
We're not foraging because, first of all, any of those, the one thing that really is perplexing to me is why the government wants to not turn this over when clearly in the other cases he cooperated, it was discoverable. Whether those people pled pre-indictment, not pre-indictment, or any other.
It was discoverable to those defendants.
Correct.
To those defendants.
To those defendants.
But that was directly relevant to those cases.
But understandably,
So
though,
why don't you get it from those defendants then?
because it appears from what we learned that they weren't turned over to those defendants, what we learned, because I was at the trial below.
You
that-
just said that they were turned over those defendants.
No,
Why
I said
shouldn't
they
get-
should have been. They would have had to have been. And we're not clear if they were all turned over. And it wasn't made clear at the trial court below.
Because
But-
you're not counsel in those cases. You don't know what's gone on.
No,
before them.
but the representation was made by the attorney generals in the case below.
So that attorney in that other case for that defendant clearly has a motion they can make at this point in time that Brady has been violated and their client's interests have been affected.
I would think so. I
So-
mean, if that's accurate. I don't know if that's accurate.
just
or somebody just
represented
spoke.
it.
Let's stick with the record in this case.
I also want to understand the implications of the argument that you're making. And from what I can see, what you're suggesting is if there's a cooperating witness in one case, and the person happens to set up undercover drug buys, and is involved in 50 other cases, and gives statements to the police about that, you want everything. You want those other 50 cases. You want every single statement, every single wire. Is that? Do I have the drift of what
You have
you're
the drift,
arguing?
yes, Judge. You have the drift. Because also these investigations, is my understanding, were going on simultaneously. And if there was an ability for this person to receive drugs from somewhere else and then attribute them to my client, then I think we should be allowed to explore that. There is not a police witness in this case as to anything directly.
But that goes directly against the argument with regard to the incentives based upon this cooperation agreement, because if the theory is that the CW was sending everybody is cutting off other investigations to send everybody to your client, that really would be that would make no sense with respect to his cooperation agreement.
Well,
He's going to get
you've got to understand the involvement of this cooperating witness. He was involved in a violent sect of the Bloods. He clearly had a cap of how much cooperation he could get, of how far they'd reduce it. So he might have had throwaways, and maybe that's very speculative. But that's the problem. A lot of this is speculative because of the cooperation agreement. But we know this is not something we made up.
you can cross-examine that witness at trial effectively with respect to incentives in that cooperation agreement.
I don't think I can. I don't think that I can effectively cross-examine a witness by just a piece of paper that says, here's your cooperation agreement. Mazur talks to that when it talked about a cooperation witness when he had an investigation dismissed against him, so he cooperated against Atlantic City police officers, and they'd stop an investigation. And Mazur used the word was the language in that case, which is really goes to the heart here, is how could you effectively cross-examine on bias if you don't know what the benefit was that they received by the underlying details of that investigation that was stopped?
Mr. Korbanix, I want to go back to one of your earlier answers and give you a chance to flesh it out. You said the trial judge is going to be the gatekeeper here. You're asking that the state turn over all this information to the judge to make a determination of what's relevant and then disclose that to you. So tell us, what would you argue to the judge? Judge, keep an eye out for this kind of information because I'm entitled to it in order to defend my client. Fill in those blanks for us.
I would like to know about the information that the cooperating witness said about people having guns, because in more than one instance in the first cooperation agreement, there had to have been, logically, statements giving that certain people possess guns.
That's in your case or a different case?
Justice, I hate to assume it's in my case, but it appears it would be, but I only have a redacted copy of the first cooperation agreement.
So, and I have the January agreement in front of me here.
Yeah, and I think it's 4I.
4BI doesn't.
When it lays out all the investigations. His first one names our two clients.
Correct, and there's no mention of guns there. Are you?
In
I don't have the earlier agreement in front of me. Does that reference guns as to your clients?
Well, that paragraph has two names blacked out that was provided to us in the first agreement.
But if there were guns in your case, wouldn't they have to turn over the relevant discovery in your case in any event?
That's correct. But what I'm saying is my client's not charged with guns.
I
So what I'm
understand.
saying is there clearly had to have been a statement given about our clients having guns that was either misleading or incorrect or goes to the credibility of the only witness in this case.
So you're asking in that instance, in the example you've given, about information relating to your client and the co-defendant. Fair. My question relates to, you're talking to the judge about the other cases. What are you asking the judge to look out for as relates to the other defendants that you should get in order to be able to defend your client?
I believe in those other cases to defend my client and be an effective cross-examiner that I should be able to have all the statements that were misleading as to other people that he was seeking a benefit for, because that clearly would show a greater bias toward being successful here, since he couldn't come up with the bonus points in the other case, but he told them he could.
So if following up on Ms. Henderson's representation, the court were to direct that you have to provide misleading or false information, are you covered?
No.
Tell us why.
I think that determination is best made by a judge who is neutral. I think with the open rules of discovery that the state of New Jersey has, that we are entitled to it directly, but I'll concede that if I can't get it directly, that a neutral judge should be able to look at that and say, you know what? I think that's misleading, as opposed to maybe a prosecutor who is an advocate for the state of New Jersey and is doing the best to present their cases, may not look at it in such a neutral light.
So just circling back to the issue of tapes, let's say there's 100 hours of tapes in these other cases. Where in all of that is the trial judge supposed to spot what you're looking for?
Well, that's maybe Listen, if the trial judge would rather go through hundreds of hours of tapes as opposed to me, that's fine.
I don't
mean,
even,
would-
I can't even figure out how you get this in.
Yeah.
Even in another case, if there was a misleading or inconsistent statement, how do you get that in your case? Tell me, under
I-
our rules of evidence, how would you manage that?
Well, if it was, at this point, it's very difficult for me to talk about that without hearing the tapes. But what a few things could be is, once again, if in fact they were deflecting from one person, if he mentions a name in there that perhaps through our investigation can lead to discovery, it's very speculative at this point in time. But I do believe that we'd be entitled to him, and I don't understand why.
You would not be able to ask the witness, tell me if I'm mistaken about this. You could not ask the witness, isn't it a fact that you gave a misleading statement in another case? You couldn't ask that question, could you?
I believe I may be able to. See, and that's where it comes in with the trial judge being so.
I don't know under what rule of evidence you could do that.
Maybe under context. It may be under context. The trial judge, if the things happen in a trial situation that we cannot plan. Things we thought were irrelevant become irrelevant.
It would be
People
one.
open
It would
doors.
be one thing if you were able to show that he made false accusations in 3 other cases. That you'd probably be able to get in, but we're not talking about that. You don't have that. You're not making out. You're not making out anything near.
But we
a
don't
case
know
of
that
any-
yet. How do we know that without being able to thoroughly prepare for cross-examination through these materials? We don't know that till we look at these materials.
Don't you have the cooperation, all the cooperation agreements of this cooperating witness? You have all those.
Yes.
So you know in those cooperation agreements what he's trying to do and what cases might have evolved from those cooperating agreements, right?
Right.
And you know the outcomes of any of those cases, whether there were indictments, whether there were pleas, whether there were convictions. You know all that from what's already been provided, right?
Well, I know the conclusions. Yes.
Right.
I don't
Well,
know the premises.
Outcomes, conclusions, whatever. You know all that. So how is that not exactly what you just said you need? You got it. What else do you need
I need the basis for that because it's
for that
that's-
outcome?
Correct. Because the indictment says our clients did so many things. That's
And the reason that's relevant is what?
well, I'm saying to make an analogy is I need the underlying facts that led to these cooperation agreements to show the bias of this witness.
Can I ask, those cooperation agreements, did they lead to guilty pleas in other cases?
We don't have all the information. We believe that they led to some. In the one case we know is the case that he pled to. Is it led to, I believe, almost all guilty pleas. There were other investigations that were ongoing at the same time.
How many
Rio.
guilty pleas would that be?
I think I'd be guessing. The number 18's in my head, but I don't know why.
So are you trying to, deconstruct or a case? They pled to 2 drug charges. They were indicted for 10 drug charges and 5 weapons offenses. This first cooperating agreement refers to guns. If I can produce guns, I get 6 months or a year credit on my stip. Is that what you're trying to do, to be able to take a judgment of conviction and back it all the way up to original? And because he pled to, have 2 people pleading to drugs and not guns, to infer that he gave misleading information?
Not at all. Not at all. When I'm talking about the guns, things of that nature, I want to know what was when he gave the information about the guns in the first cooperation agreement.
What was the basis of, what was like the bona fide basis for
What
him
was
to
his
say,
statement?
I know they deal in guns, or I know they carry? Is
Yes.
that what you want?
And I'd like to know why then,
Okay.
if he knows that, why then was it left out of the superseding agreement?
Anything you'd like to add to your presentation?
No, Jim.
Thank you.
Thank you.
Mr. Alvarez.
Thank you, Your Honors. When the state was up here, they indicated that this discovery order was unprecedented. The only thing that's unprecedented, in my opinion, is their attempt to try to hamstring our client's ability to defend themselves in this case. To be clear, what we're after here, the central key of this case is the credibility of the cooperating witness, Mr. Darrell Gilbert. He was the only one who has witnessed the alleged transactions. There was no one else with him. No one else could see into the location where he was. He wore body wire, but only one transaction was recorded. So everything rests and falls on his credibility on that witness stand. Now, he's brought into this case by virtue of the superseding cooperation agreement. That creates a problem because that agreement encompasses a number of different investigations. And the material we're looking for goes towards the integrity of that agreement and the integrity of him as a witness in this case. Why? Because the superseding cooperation agreement lists 6 cases that he's supposed to work for them on, and the 7th being his underlying case. Then we have a representation from the Attorney General in the matter, the trial Attorney General, Mr. Militello, that, and I'm looking at transcript marked 1T, page 12, lines 23 to 25, that, and I'll read directly, so we're 3 cases where he worked plus his original one. So total 4 cases where he's really involved and did something substantive. That means there's another 3 cases that he didn't do something substantive or he wasn't really involved. Yet he gave information that led to a cooperation agreement where he was supposed to get a successful prosecution on those cases. And the cooperation agreements are keyed to the statements he provides. In each cooperation agreement, it says he's supposed to give information and provide information consistent with 3 proffers he gave. A proffer on July 21st, 2011, October 21st, July 17th, I'm sorry, October 21st, and October 26th, 2011. If he's giving information and those proffers towards investigations 1 through 6, or 1 through 5 in the original cooperation agreement, and some of those investigations don't pan out as indicated by the Deputy Attorney General at the trial level, we should be able to see that material to see why they didn't pan out. It's not enough that the state makes a representation to us that no, those didn't pan out because they just didn't work out, or it wasn't a material inconsistency that he stated. That's not good enough for us. The proffers, in my experience, and admittedly I don't have the experience that counsel has here, but I've had a number of clients who are cooperators, and they go in for proffers multiple times. The reason being is each proffer is a test of his credibility and reliability for the information he's giving. We should be entitled to see those, because if there's any inconsistencies in those, what may be trivial to the state may actually be exceptional to us and to a jury. And that's the heart of this issue. That's why we need to review all this material to see where that is and see what's available. Because, and to address Justice Albin's question, the case alluded to was State v. Ballard, where it was cited by the Appellate Division, page 6, and it stands for proposition that discovery is appropriate if it will lead to relevant and material information. Not that the material itself is relevant, but that it could lead to relevant information. And the credibility of the state's virtually only witness in this matter is material. And the fact that he's brought to our case by this cooperation agreement, which encompasses a number of investigations, because in effect, it's as if he was deputized by the state to run a number of investigations. He said, I'm in trouble, I want to work off my time, and I'll give you these in addition to my underlying indictment. And I'll give you X, Y, and Z. And in return, he was getting 18 months, 12 months, 6 months, depending on the degree. That fact, because they're all interdependent and depending on how he does on one, alters the other, is material, or can be material, depending on what he said and how he went about to do it. And the trial judge was very clear. Just because something is discoverable doesn't necessarily follow that it's relevant or admissible.
So follow your standard. Suppose he had offered to give information in the Jones case, one of the other 5, and that case never panned out. Tell us how that information will lead to relevant and material information for use in your case.
Well, if that case is part
Give
of...
us an example.
Right, as an example, if that case is number 5 in the superseding cooperation agreement, he had previously made a statement that Mr. Jones is a leader of a narcotics trafficking organization, and I know this because I spent time with him, I purchased from people that he's involved with, and from, I've worked for him in the past. I know where he sets things up and how he operates, and he's supposed to do that investigation. And time comes when he's doing that investigation, he's trying to make a purchase or whatever, and nothing happens. He's either can't get in touch with him, or he's ignored by the individual, or the individual says, no, I don't know what you're talking about. That information presumably would go in a report, which would say the information, Mr. Gilbert's attempt to purchase from Mr. Jones ineffective, unlike what he had said on October 21st, 2011. And that goes right to his credibility because it's part of the very cooperation agreement that brought him to our case.
How would you get that in?
There are 100 reasons that could be, yeah.
So the witness is on the stand, and so in some other case he said, I think I can rope in this drug dealer, Z, and he doesn't do it. He's on the stand. You think you can question him about that? How would you get that in under our rules of evidence?
Well, and I think the admissibility of that evidence is a question for another day.
Why?
And
the question is, will it lead to relevant evidence? If it's not leading to anything other than down a rabbit hole, then where are you going with it?
The relevancy and admissibility of that evidence would have to be dealt with at the trial level. We would have to admittedly come up with an argument to try and get that in, and that's for that day.
But if you can't articulate a reason now, then why should all this information be disclosed to you? Giving you the best scenario. He says, I can rope in Z, and he doesn't do it. How is that going to be relevant in your drug trial?
It could go to his credibility as a cooperating witness in this case, and all his...
I don't know how you're going to get that in. That seems to me collateral.
And admittedly, that would be an issue that we'd have to flesh out at the trial level.
But you do have to justify the discovery order at this stage. So how do you do that?
Because it could lead to relevant material evidence.
Can you give us a hypothetical? Because it was your hypothetical that we were just talking about, and I think even you had to concede that it's a very, very long shot on getting that in. Can you give us a hypothetical where evidence would be admissible in your case, based on this scenario?
Well, in the first cooperation, I'll take that by example. It mentions on DA 12 under 4, the investigation 4, mentions a CDS on Communipal Avenue. And then the first time our clients are mentioned are in the second cooperation agreement by name. Now, they were arrested right around Communipal Avenue. He's providing information that there's some sort of drug transaction at Communipal Avenue.
See, right
If-
there, you've got the agreement. You can cross-examine him on that.
But the difference is between the first and the second. If at the first time he gave the statement was Communipal Avenue is run by X drug dealer, and then he says, oh no, I was wrong, it's actually Y, and they're the ones who are arrested, it's an inconsistency in that very same investigation, the very same location of where he's supposed to investigate.
Anything you'd like to add?
Nothing further.
Thank you. Mr. Lesper?
Happy New Year. Good morning. May it please the court. I'm going to try to answer all those questions, including referring you to the rules of evidence where appropriate, which I went back to the table to pick up. But before I do, let me just set the context in two ways that I think are very critical here. The first is that this case arises in the context of a state which I'm very proud to practice in has pretty much open file discovery. That is, we don't, as this court has said on numerous occasions in the past, proceed through trial by ambush. We know what the other side's case is, and we go in with full information. To a certain extent, I'm anticipating the next question, which is, well, which file? And I'm going to get to that, why this is all part of that same file. But that is our tradition. And part of what the state is doing here that to me is very distressing is attacking that tradition, is saying that, no, it was inappropriate to limit the discovery in a way that, in a state where we don't really limit discovery, where we believe in broad discovery. So that's context number one. Context number two, and this is critical, is that this comes before this court after a pretty extraordinary set of proceedings in the trial court. The standard that this court uses to evaluate the decision of the trial judge is whether she abused her discretion in allowing the discovery here. And she did not abuse her discretion. What she did is the furthest thing from an abuse. She held lengthy hearings, she limited the request, she redacted harmful information, she was very solicitous of the potential problems of endangering a witness. At the end of the day, one of the things that the state objects to most is that she made them do a privilege log, which is the furthest thing from objectionable and is clearly contemplated by the rules. She engaged in precisely the type of conduct that we want trial judges to engage in, including, and this is perhaps most critical, an in-camera review. So we were not dealing here with hypothetically stuff that might or might not be relevant. We really were not in the context of a fishing expedition because we had a trial judge who was behaving responsibly to make sure it wasn't that at all.
But you're not suggesting, Mr. Lesberg, that process makes for a fair result. I mean, you can have judges go through hearings for months and go through in-camera reviews and simply reach an incorrect decision.
Of course, but not merely incorrect, Your Honor. I mean, it would have to be an abuse of discretion.
There can be an abuse of discretion. So take us beyond process.
Okay.
Because, with great respect to the trial court, there was a great deal of attention paid to this case. But our task here, and of course the appellate division found it to be an abuse of discretion, our task here is to determine whether the result was an abuse of her discretion.
Yes, and that's exactly where I'm going next. This was not a fishing expedition, respectfully, and here's the reason why. Because the witness in this case came to this case as not just the witness in this case. By virtue of the particular cooperation agreements that were provided, and the particular cooperation agreement in this case which provides a discount off his sentence seriatim for his successes in these various cases, and I do now wish I had raised the due process concerns that are inherent in that, but that's not before this court. But what comes before what we're dealing with in terms of a witness is a particular witness who's engaged in all of these other things. That is part of this file. That is part of the open file that there should have been. All the things that this witness did. But that leads inevitably to the question of what would the defense have done with it. That is to say, okay, everybody agrees there's certain information that was received, and yes, any good trial lawyer could do, and there's good trial lawyers on the other side here, could absolutely do a lot with the very fact of cooperation and all the incentives. So the question that you all keep asking is, why isn't that enough? Why isn't it enough to just give them the cooperation agreements and let people cross-examine based on this? What do you need all those facts for? And so I'd like to try to lay that out for you in a way that I hope will make some sense. In my view, there are at least three incredibly valuable areas, to use Mr. Korbanik's term, without which, if they were not explored, could create potential ineffective assistance of counsel claims, but certainly which go to the fairness of the trial. First and foremost, there's the question of prior inconsistent statements, or prior statements. And I want to go directly to Justice Albin's concern. How do you get it in if somebody... Let's take a great example of something that I guarantee you happened in this case, and I don't know a thing about it. In one of these proffers, the defendant didn't tell exactly the truth, because the proffer process, as we all know, is one in which the witnesses typically might say something, maybe minimize their conduct the first time, then they come a little cleaner the next time, then they come a little cleaner the next time. That, to me, goes to credibility. And to me, there's no question but that you should be able to cross-examine and say, even if it was in a different case, when you came forward the first time, you didn't tell them everything. In fact, you just said this. Now, your question is, how do you get that in?
Under our rules of evidence.
Under your rules of evidence, not the federal rules.
Under ours. Yours and ours, state.
So these are the ones. So these are the ones.
Good.
I'm
I'm glad you have them. Look at 607.
I'm using our rules. I'm looking at 607 and 608B.
Go ahead.
It's got the correct cover, but we're not sure what's in there.
Okay. Well, these I think are the state ones. I didn't. In fact, they're Mr. Alvarez's. So Rule 607 says, except as otherwise provided by Rules 405 and 608, we'll get to 608, for the purpose of impairing or supporting the credibility of witness, any party, including the party calling the witness, may examine the witness and introduce extrinsic evidence relevant to the issue of credibility. That's it. That's the answer.
No, it's not the answer. Now look at 405 and 608.
So 608.
Because 405 because 608 will tell you the specific, and 609, the specific instances of conduct to impeach credibility are limited to 608B.
Okay.
And then you have to look at 405 that talks about doing it in terms of opinion testimony.
Okay, so we're not talking about opinion testimony.
I understand that.
Okay, so we're talking about, so I'm exactly where I was going next, which is 608B. So 608B says, the credibility of a witness in a criminal case may be attacked by evidence that the witness made a prior false accusation against any person, and so forth. That's the question. So here's what plays out in this court today. You ask the state, what about if there's a prior false accusation? The state says, don't worry, we'll hand that over in discovery. That's Brady. We have to provide that. Trust us, we'll do it. I think there's plenty of evidence to be concerned about whether that happens in every case, but here's the real point. The real point is, what is significant there is, to a great extent, in the eye of the beholder. What makes for a false accusation is, to a certain extent, in the eye of the beholder. They say, well, they could be little minimal things that aren't really material. Well, those may make a huge difference to me, and I can tell you, those may make a huge difference.
So our case law helps determine what a false accusation is.
Right.
It's like falsely implicating someone in a crime, not the sort of prior inconsistent statement that you were earlier referring to.
Well, but it depends, because what implicates a person in a crime, as we all know, may be various links in a chain. And so various small facts may or may not, it isn't required under our case law, under this court's case law, that it has to be one big false accusation. He did it. No, it could be a particular fact that leads to another fact, that leads to another fact, all of which intend to implicate the defendant.
If you look at our case law, and since I wrote part of it, that led to the little piece you're talking about, you couldn't get in. We specifically said we're not going to permit mini trials in other cases, okay, to take the attention of the jury away from the main event. We said specifically we're not going to permit that unless you can really show that on previous occasions the witness, sometimes the victim, falsely accused someone of the same event. If you can do that, and it's not going to create a mini trial, it's okay. That's what we said.
And we're going to get to that because there's no reason to believe that that doesn't happen here. But the real question here is, if you get all the statements in the prior cases, aren't you going to get exactly that kind of thing? Here you have other cases where a person may or may not have said something that rises to that level, and there's gradations in between, so that a court, maybe initially in camera, and then the defense counsel can evaluate whether in fact it falls under 608B. What we're talking about here is you're asking for, is there a theory under which this might lead to relevant evidence?
No,
And
will
here's the
lead.
theory.
Will lead, not might lead, will lead.
Well, one of the cases says may, one says will. But either
Which
way,
case says may?
I think it's called Williams.
Yeah.
It's a health vision case that came up here on a different issue. And cited in our brief. But either way, but I'm happy to go with will, because the will is determined by what's in the statement, and this goes back to your point about why process is so important. Because once the statement's produced, then this is what judges do in camera. They look at it and they say, does this rise to the level of a false accusation or of a fact that could, taken with other facts, become a false accusation?
But let's
I
use their-
agree. You can't say on such and such day you said the weather was sunny, and in fact, here's the mini trial, and weather was actually cloudy that day. Of course, I'm not talking about that. Although juries might be influenced by that too.
Let's use the hypothetical the defense counsel raised, which is that a proffer, the CW said so-and-so is running a major drug operation, and then they try to investigate that, and he doesn't return phone calls. Why does that come in this case? Or does it come in that? Let me start with that question.
Well,
He thought he could do something that he couldn't produce.
so it
He
might or
didn't
might not.
falsely. It's not a false accusation. It's not.
Got it. And so unless it somehow is related to this case in the sense that it's part of the same drug ring, it probably doesn't come in.
Okay.
But that's why this gatekeeper function is important, because in a case like this, and I don't know a lot about the facts of this case, but it seems to be a large constellation of facts there's gang issues, it's a large drug operation.
I'm trying to understand what you want our judges to do. So if you have a cooperating witness, okay, who's key witness in your case,
Mhm.
and is working in 6 different cases,
Mhm.
you want our trial judges to look over the entire file of the 6 other cases, forge through it to see whether or not the judge can find some inconsistent statements or a couple of false statements here and there? Is that going to be their job?
It wouldn't be the worst thing in the world if it were. I mean, that doesn't slow the wheels of justice to such an extent as you're making it sound. For one thing, this doesn't come up all that often. But to the extent
It will, depending on what we say here today.
No, what doesn't come up all that often is this scenario where you have a cooperating witness in one case who's cooperating in many, many other cases. I mean, that may happen some, but when that happens, there may be facts there that amount to false accusations under 608B.
This is what I'm concerned about. And maybe it's the may bit. Maybe, yes. That's the speculative part. So where do we start? Do you start out that merely because he's cooperating in other cases, because he may give false testimony or may give inconsistent testimony? You start out by reviewing every single statement.
So
and you're going to require our trial judges to look over multiple other files in other cases?
So keep in mind, this is where we are. We're in a situation where you have a cooperating witness who's cooperating against your client and has cooperated in a number of other cases. So we're in that unique context. Not completely unique, but certainly it's not every case by any stretch of the imagination. And what you're asking judges to do is to look to see, with great specificity, I don't think this is going to take that long, to look to see whether there's something that amounts to false accusations, because then there certainly is a theory by which this would come in, that would lead to relevant evidence. Yeah.
Let's go to your other 2 categories. I think
Okay.
we've exhausted this one.
Okay. Category number 2. If a defendant, if a cooperating witness in a case like this is working in numerous cases, one of the things that one always looks for in order to uncover whether the statement is accurate here is whether there's what I want to call an eerie similarity between the allegations he makes in one case and makes in others. So it's easy enough to look and say, if you see a witness who's saying the same thing in every other case, in each and every case, that requires some further explanation and could certainly be very powerful cross-examination. So that's a second category. That is to say,
If he says he was buying cocaine from 7 people, that's an eerie similarity?
no, that would be too general. But if there's this, I mean, I've seen this so many times. If you have a situation where the person is essentially telling the same story over and over and over, you start to wonder, is that their story that they tell in every single case? And that's important, powerful evidence. And by the way, the social science that you referred to talks a lot about how one of the ways that you get out from under this horrible problem of unjust convictions based upon this type of evidence is to look to see whether the stories all line up in just that kind of way. That kind of lineup is a critical fact that the defendant should have the opportunity to explore.
So in a drug case, tell us what you mean by that.
So I can't come up with any particular hypothesis, but you could see, there was a meeting, in the middle of the night, under the bridge, or whatever. I mean, it could be just a similar set of facts that just seems to repeat itself, so that a person who gets in trouble is telling the same story each and every time in order to try to get out of it, in order to try to reduce their sentence, and that's a second category, and the third category goes in some ways directly to bias, and this is where the appellate division's decision in Mazur comes in. Because what Mazur says is that if you really want to explore the full measure of bias, it's not enough to just have a list of cases, to say you cooperated in this case, in this case, in this case, in this case, you had all these problems, you were trying to work off your sentence. You should be able to get into the question of how powerful the evidence was, what it was that you said, that kind of thing, in order to demonstrate the full play of that bias. And in fact, what the appellate division says in Mazur is that it would be impossible, that's the appellate division's word, without getting into the facts of the case to really fully explore the extent of the bias. Because it's not enough to say, I really needed to succeed here because I was facing this exposure. The bias increases with the facts of the case, with the severity of the charges against the person, with the seriousness of the allegations.
But play that out in the context of an actual trial. Tell us what kind of cross-examination you envision.
On that?
On that third category.
On the third category of bias. So, the cross-examination would be, I think, something along these lines. The defendant, Mr. Cooperating Witness, you're cooperating in this other case. In that case, there's a particularly tough situation because what happened there is fill in the blanks. And so it's really important, since you have all this exposure as a result of those facts, that you succeed here, because otherwise you're going to face this really long sentence. And this is all part of that same cooperation. It's that sort of thing. And to go to Mr. Korbanik's point, it is the interdependence here. What creates the sort of unique scenario here is we have a cooperation agreement that links all of these cases together.
So it's the distinction between you have exposure to this amount, which you have already, in what they have.
Yeah, right, you have that.
And you are trying to reduce it, and here's the rules by which you would do that under your cooperation agreement. Between that and in case A, you got a challenge there because they're difficult facts. That's the distinction we're talking about here?
That's difficult facts, difficult other things that you've done. In order, if you get into the facts, you really fully expose what the bias is going to be. In other words, it's antiseptic to say you have a bias because you're potentially culpable in this case, and here is your number of years.
I don't see how that's even the example you gave to the Chief Justice, I don't see, how is that a bias? You gave the example of asking the witness whether he was cooperating or giving information that would lead to the conviction of other drug.
So the bias, you're right, I should flesh that out a little bit more. There's two potential forms of bias that arise. One potential form of bias is you are rooting for the state to succeed, partly because of the structure of this type of plea agreement, and so you need so your bias comes out is that you're going to you're essentially by virtue of being in all these cases, you're kind of lined up as part of the state's team.
But you've got the cooperation
That's
agreements.
That's the general one.
Okay.
So now the specific one is, and this is what all the cases are typically about. And maybe it's wrong to call it bias, but this is the way it's articulated, is that you are biased in favor of a particular version of events that will result in the greatest reduction in your exposure. That's different than rooting for the state, right?
You've got that through the cooperation agreements. I don't see how are you going to get that out through questioning the cooperating witness outside of the cooperation agreement. Without allowing the state to bring in evidence that the information provided by the cooperating witness actually led to the conviction of other people.
Well,
which is something you may not want.
And that's a tactical decision that gets made once the evidentiary at a place far distant from this. Because now what we're talking about is whether this will lead to discoverable evidence, and so that is assuming discoverable evidence, whether you still want to introduce it. That's a tactical decision that's completely aside from this argument. But no, the extent to which you feel the need to embellish, to lie, to misrepresent is going to depend not just on the charges against you, which is what's set forth in the cooperation agreement. It's going to depend on the facts of the case, and those facts are what would be revealed in these files. That's all that they're asking for. They're asking for a full opportunity to do this kind of cross-examination that can only be created with more detail than just a list of the cases.
You think that one of our courts is going to permit 5 other trials, collateral matters, along with the one on which the defendants are supposed to be determined either guilty or innocent?
That's not what would happen. I mean, what would happen would be cross-examination that would focus. I mean, we're talking about adding 2 or 3 questions to a line of cross-examination that goes to show why why the witness is particularly desperate, as opposed to just saying.
So give us those questions, okay? Those questions that you need to ask that are outside of the cooperation agreements and all the other information that Ms. Henderson said she would provide to you. Go ahead.
Okay, so what Ms. Henderson says she's going to provide is only directly false statement, what they view as directly false. That's all that she's going to provide. Nothing, so a false accusation and that's it. And by the way, what she says is that's in the eye of the beholder, and so, maybe the state will provide it and maybe they won't. So trust them. So that's all she's giving us. What's in the cooperation agreement is nothing other than this is what the charge is, and you have to cooperate. And so here's your incentive,
Go ahead.
because otherwise you're going to face this number of years. That's my cross. All I can do is, Mr. Cooperating Witness, if you don't cooperate, you're facing this amount of time, and so therefore you're really going to cooperate.
I think Justice Alvin is asking what the questions are. What are the 2 questions or 3 questions, as opposed to a mini trial,
right,
that would be generated by the discovery that they're seeking?
Give it to us.
Okay, and again, I'm making it up because we're just a hypothetical case. So the hypothetical case is, and so in this case, you were facing, they caught you doing this, and in response, you said this, and so you were in big trouble, and so you really need to tell this version of events here. It's that kind of thing. That is to say,
Why doesn't that come in based on the information you have?
Because that's
You're
not
in
what's...
trouble. You have all that information.
No, we don't. We have the in trouble part.
The problem that the cooperator, him or herself, faces, you have. That has nothing to do with the other cases.
No, I'm talking about the other cases. This is no, we're not talking about this case. So one of the questions
You've
that's
got
in
that. With the cooperation agreements, you have those questions.
You
could say to the witness,
right,
you're in a desperate situation. Unless you give the state heads, in this case, that case, and in my case, you're going to prison.
right.
You have those questions already.
Then that's all I have, and I agree. That's what I have. But think about how much more effective it is if I can also point to particular facts that make him even more desperate. Pardon me?
For example.
For example, that you were caught red-handed with this, or that you lied when you were arrested, or that you fled when the police came, or all kinds
In
of
other
things.
cases?
Yes, in other
You
cases.
think you can get that out?
No, but you're telling me that I can cross-examine on those other cases, but all I can ask, which are part of the same cooperation agreement, but all I can ask for in those other cases is his exposure. I can't ask about any of the facts. So, and by the way, again, the standard here is not, maybe a judge looks at it and says, you know what, the probative value is outweighed by the prejudice, we're not going to allow it. But that is what trials are for, and that's what trial judges do. Here, the question is, are you going to allow an investigation by the defense? You're going to provide them evidence, that, the discovery, so that they can investigate it themselves, so they can see whether this witness has been involved in cases like this in the past, where they've taken actions that make them particularly inclined to lie here. Not that they're facing additional time from these other cases, which is all that's in the cooperation agreement, but that there are facts that make them more desperate and therefore more likely to lie. That's the sum of it.
Anything you'd like to add?
No, thank you.
Thank you, Mr. Lusberg. Ms. Henderson?
Your Honor, I'm going to waive rebuttal, unless you have any questions.
I have one at least.
Sure.
I don't have the first agreement in front of me, as I mentioned. Is there anything, as relates to this case, redacted from the first cooperation agreement, DA-12?
I haven't looked at them in a while. I believe the only thing redacted was there was some gang reference and some reference to gang activity, that they redacted the names, I think, of the gangs and the individuals. But on that point, the discovery motion in this case never asked for the judge to look in camera at the unredacted cooperation agreement, the first one, to see what it was and see it was material. There was never any question about, the one thing they never asked about were the cooperation agreements. There was nothing in this discovery that said, we want to know, what was redacted in the first one. I'm not sure they're permitted to ask why we changed it. I mean, that's a different issue. If we change a cooperation agreement with an individual, and certainly between the two agreements, I think the thing that happened was that we got the first degree case on them. So that may have altered the agreement, but there's never any allegation that guns were involved with these defendants, and there's certainly no allegation that gangs were involved with these defendants, because I know it came up in the trial court that they thought they could cross-examine this cooperating witness that he was a gang member. What has that got to do with anything? This is not a gang case. They were not affiliated with these people, and as far as I know, they're not gang people, so it was just throwing out everything they could think of. It's like, well, we're going to ask him about if he's a gang member, and we're going to ask this, but this is the first time I'm hearing about their problem with the two agreements, that something was redacted. If that was a complaint, they could have raised it below, and I'm sure there'd be no problem with the state submitting the unredacted cooperation agreement to the judge to look at, unless there are any other questions.
Thank you. Thank you, counsel. We'll take the matter under...
I guess there was something that wasn't accurate.
You got to come to the center. Thank you.
I appreciate the court giving me this opportunity, because this is an admitted gang member. That's why the cooperation agreement became so important, because, and I hope I articulated this, is that there may be reasons for him to do certain things and give certain misleading statements because of the fact that he's a gang member and was a member of a big gang.
Thank you, Mr. Portman. Thank you, counsel. We'll take the matter under advisement. Do we need a break? We'll take a quick break and be back for State versus McFarland.